Good morning, and welcome to Coffee Colloquy. Oh, so it is Sunday morning, September the 16th, 2018. We are here in my wonderful living room, which is a change. Normally I do streams from the den, but we moved the computer in here because some people don't know how to pick up the goddamn living room, and we figured that if it was broadcast out to the internet, maybe people would actually learn how to do things. So this is a new one for us. This is a brand new thing that we're trying to do, and it's a once-a-week sit-down for about an hour where we talk about legal developments over the week, have a little chat with the chat room, and generally be lawyers. So here we are, Coffee Colloquy, week 1. So, what the hell are we going to do today? I have no idea. I have absolutely no idea. This kind of has been discussed back and forth a little bit over the past couple weeks here on doing a show like this. There's plenty of attorneys out there that do these. Chad Murray out in Illinois does a series of YouTube videos about different topics. Leonard French, who's only about an hour out of the road here, does a game stream over on Twitch where he talks about the law for an hour or so, a few hours over the weekends. And I figured that it would be nice just to sit down and rather than do a podcast with Lawyers and Liquor, because we've tried that several times and it has completely failed us all, to do something like this. Now, few notes. First, I have no clue how many of you there are. I could be talking to myself right now. But if you're in the chat room and you want to chime in on a conversation that we're having, on a topic we're discussing, something along those lines, feel completely free to do that. I will be glancing over at the chat room, and we'll be able to discuss that stuff. Second note, it's a very honest one. And you should all understand this by now, especially if you follow me, especially if you read the website, which is lawyersandliquor.com. Especially if you've spent any time talking to me at all, online, offline, on the phone, via telegraph, sending smoke signals out in the backyard. It's a standard disclaimer. I am a lawyer. I am not your lawyer. Unless you have come into my office, sat down, met with me, discussed a legal issue, I have agreed to represent you in the matter. You are within my state to do all of these things, and you have paid me a retainer of my choosing. Don't just PayPal me $1 and say, okay, you're my lawyer now. This is not legal advice. This is an educational and informational discussion of current legal issues, news stories, and a little bit of fun. Please, for the love of God, no matter what you do after this point, don't go out there tomorrow and say, a guy on the internet sitting in his living room told me this, therefore I am entitled to do everything I want. It doesn't work like that. We're not going to have a lot of sound, so there's absolutely no point in me wearing headphones past making sure that's in. I had to get up early this morning, shower, shave, do my hair, get dressed, sit down, do all of this, so I have my coffee. And on top of this coffee, I have another coffee. And on top of the other coffee, I have a soda. And on top of the soda, I have a pack of cigarettes. So I'm going to be well and truly hopped up this morning. Okay? So give me 1 second, guys. We're just going to flick over, make sure everything's working, and then I'll be right back, and we'll start Coffee Colloquy. All right, so we're back. It looks like we're set up, and let's just go right into the first story of the weekend, okay? Obviously, somebody out there is expecting me to talk about Hurricane Florence. I'm not going to talk about Hurricane Florence. Everybody else has talked about Hurricane Florence. We know there was a hurricane. We know it hit North Carolina. We know it's going to impact legal things. Now, one interesting thing, and I can't get to this article because it's behind a paywall, and I refuse to pay for law.com, is that there was an interview with an attorney in the, I believe, Wilmington area, who, when asked if he was vacating for Hurricane Florence, actually said, no, my office will be open until the winds begin to blow and the waters begin to rise because I don't get paid if my office is closed. Which is accurate. There's a lot of small solo attorneys in that area who are no longer going to be able to access their offices until this disaster is over. So if you are a lawyer, if you're in the legal professions, if you like lawyers, think about those guys because they're about to lose a lot of income, which is not a patch on the lives that have been lost already. But this is a law podcast, or law, whatever the hell we're doing. So we're going to talk about the lawyers for a minute. And that's not an uncommon way to handle things. A lot of attorneys handle things exactly like that, especially if they're solos, they're not at big firms. If their doors aren't open, they're not making money. So let's keep them in mind. There were a lot of lawyers after the Harvey that had that issue. But without any further ado, we're going to move on directly over to a couple of hot-button issues where we'll come back and check the chat in between each story. These are all coming to us from the ABA Journal today. Since I put it together kind of on the fly this morning after I woke up, it may not be the most interesting stories in the world, but they are at least stories. Oh, look, it's not working. How wonderful is that? How nice is it to know that that's not working now? I made sure it was working right before we started all this, and now it's just kind of telling me to go fuck myself, isn't it? Come on. There we go. There we go, baby. Keep going. Keep going. There we go. There we go. Oh, look. It hates me. It hates me this morning. Everything hates me this morning. Oh, that may be why. There we go. Alright guys, our first story this morning is a very, very simple one. It's a very, very easy one. It's from the ABA Journal. It's a piece by Patrick McClone asking, can licensed legal paraprofessionals narrow the access to justice gap? Now, we're not going to sit here and read this on stream, but the question is can a licensed paralegal, can a paraprofessional, what we call non-attorney staff, limit the gap in access to justice? Access to justice, if you're not an attorney, if you're not aware, is the question that we have at law on whether or not somebody can afford an attorney and what we can do to fit that. Okay, a lot of people don't know this. You're not entitled to an attorney in anything but a criminal proceeding. Now, there are some criminal matters out or civil matters out there, normally things like losing a child to the state and things like that, where you're entitled to an attorney for those, because it's such an extreme deprivation of a liberty and of a right that we can't go through with it without an attorney. And equity demands that somebody, fairness and equity demand that somebody be represented in that process. However, in the vast majority of civil matters, there is absolutely no right to an attorney, which doesn't make a lot of sense. All right, a criminal matter, yes, somebody's going to jail, they're losing their freedom. The loss of liberty, which is a fundamental right of humanity, is how we justify giving people public defenders. However, in civil matters, the consequences can be just as high. Somebody can lose their house, they can lose their car, they can be saddled with crippling debt that's going to, for the remainder of their lives, put them in a horrible position. And that's why, if you ask me, people should have access to attorneys during civil matters. However, if every attorney was free, none of us would get paid. So the question becomes, what do you do with low and moderate income people who may not be able to afford an attorney, really? Do you just say, good fucking luck, and send them out there? When you talk to people like Mr. McClone, the answer is no. And this has been a question for attorneys for a long time on how do you accomplish the goal of making sure people have access to justice. How do you make sure people have the ability to contact an attorney and good representation in the courts during civil matters where we say, hey, Gideon v. Wainwright doesn't apply. Gideon being the case that guaranteed people a public defender in criminal matters. Which we'll go into that in another one. Trust me. We'll talk about Gideon v. Wainwright at some point down the road. But how do you guarantee these low to moderate income people competent representation in a variety of civil matters? Now, we have over time, as a profession, come up with a number of ways to handle this. There is, well, first the opinion of we can have civil law clinics out there. Civil law clinics generally are second and third year law students who are working under a supervising attorney to provide limited representation to indigent, to poor people, to low-income people who otherwise could not afford an attorney in their civil matters. Normally talking about landlord-tenants, simple divorces, very simple child custody 9 times out of 10. We're not talking about the complicated fights. Some foreclosure issues, credit card defense, things like that. Now, that's one method. The other is legal aid. Legal aid is becoming much less viable. And there's reasons behind that. One of them being that most legal aid sources, as we wrote about on the site a while back, are actually funded in part by a federal program that gives grants to this. Legal aid is the same thing. It's kind of a charitable organization set up by each state or each organization. They take grants. Their attorneys are paid by the organization, and they provide normally much more complex representation than your standard civil law clinics going to, and receive funding from these. One of the sources that they receive funding for this from is the federal government. The federal government has slashed the legal aid budget, and our dear President Cheeto Burrito III has decided that the legal aid funding may not be necessary in the future. Another way attorneys tend to handle this are not pro bono, but low bono. Now, my office is part of a low bono program where we call it modest means. People come in, they don't qualify for legal aid. And to give you an idea, to qualify for a legal aid program, you pretty much have to be broke. I mean, you almost have to have absolutely nothing at the end of the day to qualify for legal aid, which is where you don't have to pay your civil attorney. Low bono is a little different. They have, at least in my area, a program where you go into our local bar association. They do a modest means intake for you. If you don't qualify for the legal aid services, they then send you out to a number of attorneys, and we agree to take very, very reduced fees. To give you an example of how this works, there's certain matters in that program that I'll take normally. If they were to come to me through the door, normal basis, we're talking $1,000 retainer, and then I'm billing it hourly after that. But sometimes something will come in through that program, and the way the program's structured is they get 2 hearings, which on some of these matters are all you need. 2 hearings are the typical, and they pay $450, and I don't bill them anything. Then if I do bill hourly, I bill it like $75 an hour going forward. That's the modest means program. That's what low bono is. Low bono, much, much, much reduced rate. Some attorneys, though, have stepped away from that, and they have started doing low bono cases on their own, like sliding fee scale. What can you afford, and I'll represent you. Now, I have mixed feelings. The key to having mixed feelings, guys, is sometimes as an attorney, the prospect of your client having to pay is what gets the job done. It's what gets the litigation taken care of. One of the cases I hate to work them, is things like legal aid cases where you have a client who doesn't have a great position. I mean, they just don't. They don't have a great position, but you think you can help them. The key is, though, is if you're going for a settlement, nobody's ever happy with the settlement. Neither side is 100% happy with the way a settlement comes out. That's why it's a compromise between the parties. When you have a legal aid person out there, though, they're not paying for their attorney. They're getting their attorney for free. Settlement becomes a bit harder to talk them into. And I've done both. I've done legal aid work before. I did legal aid work when I was in law school as part of a clinic. I've taken pro bono cases since then. And I have to say those clients are difficult to deal with because they don't have that incentive. There's no financial incentive for them to compromise outside of if we lose. And let me tell you, at the end of the day, most people never believe they're going to lose their lawsuit. But back to the article we were talking about. Mr. McGlone, Patrick McGlone, has suggested, and many others have suggested as well, that we should give paralegals a little more power in handling the cases that come across the desk. Standard cases, typical cases, things that somebody may be able to resolve with one court appearance and the law is very well settled. We're talking like maybe landlord cases here, eviction defense, things like that. The idea being that they have a limited license for a very limited number of things that an attorney then supervises, essentially making kind of like the law school clinic program a professional thing for people with paralegal degrees called paraprofessionals. We're not going to get into the debate over what's the proper term for legal support staff on here. here's the thing. I don't agree with this, and I don't agree with it because it increases access to justice. I don't agree with it because it puts another step between when people decide they need an attorney versus when they think they can do it with something less than an attorney. I don't disagree with it because it could cut into my bottom line. I disagree with it because there are certain nuances and matters, even in the most typical legal cases, that only an attorney who has been through 3 years of law school and God knows how much on-the-job training, depending on how long they've been in practice, is going to be able to recognize and argue sufficiently. While you have one attorney supervising these paraprofessionals, the fact of the matter is you have an attorney supervising 30 paralegals who are no longer just preparing documents or researching a matter or helping with brief drafting, but representing clients and drafting these documents to file it. You're going to increase the workload. And at the end of the day, I think that's dangerous. I think while it may do good, there are people out there who will definitely be harmed if we remove the requirements of training and ethical responsibility from the person who is actually handling the case. However, the fact remains, we do have to do something about the access to justice gap. People do have to be able to access attorneys and to afford attorneys. Years ago, the solution was build more law schools, make more lawyers. That has not worked out. It has not worked. It worked out for a while, but the end result is we have a lot of unemployed lawyers who are coming out of law school with a heavy debt load, looking for a six-figure job that doesn't exist anymore, and your standard day-to-day practice. So what is the answer? I don't have one. I don't think anybody has. Increase funding for legal aid programs? I'd be behind that. Give students who participate in clinic opportunities a student loan discount or something. Access it at the attorney level. Increase funding. Get more pro bono attorneys out there. Waive CLE requirements for attorneys that take on a pro bono case. Look, if I can take 2 pro bono cases a year and save $1,200 in CLE expenses, I'm going to. I'll take those 2 cases. It's worth it to me. But something like that. Other states have figured out different ways. Washington, for example, from what I see, requires you to do a certain amount of pro bono work. New York State, I remember this from law school, when I was leaving law school, was getting ready to put into place requirements that to be licensed by the bar, you have to do a certain number of pro bono hours within the year. Things like that. Those are wonderful opportunities. But letting people without the level of training required to practice law, I can't agree with that. All right, so we moved on from that one on to our next one for the day, and this one's actually really interesting to me. And once again, the fucking browser has decided it hates me. This one is a couple's divorce terms are vacated because a judge has ghost-written the opinion. Now, it's very simple. A district judge in Iowa has been making orders based off of what are essentially ghost-written orders. They're opinions and settlements that are being written by a lawyer who is involved in the case and submitted to the judge for approval. That's actually very standard practice. Attorneys write orders, opinions, things like that pretty much all the time as proposed orders. Not full orders, but proposed orders. Here's the difference. It turns out that this judge has been taking those and entering them as his decrees, as his divorce decrees, without checking whether opposing counsel even knew about the terms of it. Generally, when this happens, 2 lawyers are discussing the terms, we're going back and forth on it, we're going to contact each other, we're going to edit terms, we're going to do things like that throughout the course of representation, and then we both submit it with approval and with knowledge, and you copy the other attorney in on it. And everybody's aware of what's happening, and then the judge signs it as their order because it's an agreed upon order. In this case, big difference. Apparently, one lawyer was just kind of writing whatever the hell he wanted, and the judge was just kind of using it. A review of decisions, it says, found that Judge Edward Jacobson of Plymouth County, Iowa, was using ghost written opinions and in at least 13 cases failed to notify opposing counsel of that. That's fun. I can't tell you, it would make me just feel wonderful if I were to find out that my opposing counsel was essentially writing the order for every case we had in. Now, these are divorce cases, and the decrees have been vacated. In some circles, that may mean that your divorce is no longer valid. Now, imagine that. Imagine this was 2-3 years ago that this happened, and it was. The findings on this were for like June of 2016 and 15, and you have to imagine that if the judge has been doing it up till now, the judge was doing it then too. So it would be a lot of fun to find out that suddenly not only are you not divorced, but the judge gave everything away to the other side because your lawyer was never given a chance to review the proposed order that was submitted or even told that it was going to be used. The courts there have said, no, you're still divorced, which, thank God. There could be a lot of issues if you weren't. Imagine being remarried, going home to your wife and going, sweetie, the judge fucked up. I'm afraid we are now bigamists. Which, there's nothing wrong with that. It's just bigamy. The key here is ex parte communications and making sure other attorneys are aware of that. Generally, guys, if you're not an attorney out there, lawyers have a requirement that when we communicate with the court, we have to communicate with the court in a certain way. We cannot just say, hey, judge, please listen to me, and go on with it. So that's what's happened here, is lawyers did something that was actually okay in submitting proposed orders and proposed rulings, but they submitted them, it seems, directly to the judge without notifying opposing counsel of this. And then the judge used and relied on those rulings in issuing the divorce decrees. And that can, if you can't see how that may be a problem, that your ex-wife's lawyer may have completely written your divorce decree and the terms of it, and your lawyer never got to take a look at it, you have never been married and you have never been divorced. Although it'd be great. I hate to say it personally, I'd love it if a judge would just trust me enough to enter any order I wrote without any question. Next story today, but before our next story today, guys, we've been on the air for 30 minutes, and that means we have to do something. There is a gentleman in the Lawyer Slack, and if you don't know what Lawyer Slack is, it's at lawyerslack.com. It's a community run by Keith Lee of AssociatesMind.com. It is a paid community. I think it's about $100 a year, but you get member benefits. You get the chance to communicate with lawyers all over the country and talk to them, pick their brains, form a kind of camaraderie. We described it as the Mos Eisley Cantina at one point. The scum of the legal profession, all joining together online to waste hundreds of billable hours talking to each other every day of the week. It actually is a wonderful community. When I was in my car accident last year, they sent me a wonderful little fruit and nut basket to my office, which my paralegal staff immediately ate. But it was the thought that counted. Definitely the thought that counted there. But there's a member of the Lawyer Smack community. His name is Andrew Rosso. Now, Andrew is an attorney in Dayton, Ohio, and he's a very good attorney in Dayton, Ohio. I don't mean to throw any disparagement on Andrew as we talk on these matters, but Andrew is a very good attorney over in Dayton, Ohio. Very nice guy, too. He is more or less a tech attorney, a tech lawyer. And for the last year and a half to 2 years, we have been watching whether or not he is getting a verified checkmark on Twitter. Now, it's become a little bit of a thing for us. He always sends it off. He always gets these things in. So we are going to introduce one weekly segment. This is the only time I'm explaining this to you, by the way. And it is Andrew Rosso Twitter verified yet? He hasn't been to date. Let's check. Nope. No Twitter verification for Mr. Rosso, is there? So, good job, Andrew. Keep up the good work of trying to get Twitter to recognize that you exist and are a person. Maybe write another HuffPo article. Now, I joke about this, but guys, I like Andrew Rosso. I really do. I have nothing against him. He's a nice guy. He's fun to talk to. He's a young attorney and a very good one. But he's still not Twitter verified. Not at all. And it means so much to him. And that makes me so happy. Because I'm the type of guy who, even if I like you, I'm always chuckling just a little bit at your failure. As we come into the next half hour, we have something that was on Keith Lee's run this week, and it is probably the best example of lawyers ever. A lawyer in Las Vegas, Nevada, has been suspended for flashing a gun at opposing counsel and witnesses during a deposition. It says James Pingilly on September 7th was suspended by the Nevada Supreme Court after a 2016 deposition whereas he was representing himself as a defendant in a lawsuit regarding defamation and was being deposed, or was deposing the plaintiff. He he asked the plaintiff, the deponent, if they were ready for it, used vulgarities, called the deponent derogatory names, aggressively interrupted the deponent and opposing counsel, answered questions for the deponent, and repeatedly made inappropriate statements on the record. He then reached towards his hip at one point where he knew, and everybody knew, he had a gun holstered there. Depositions can get heated. If you don't know what a deposition is, if you have no clue what any of this is, you're just kind of tuning in because you saw I was doing something first, God bless you, and thank you so much for being here. But a deposition is more or less a period of time during the discovery process of any case, normally civil cases, where you can call any party or witness in, and you get to question them. You get a preview on it. So you preview out and you talk to these guys. You go through that, and you're able to find out, in theory, what they are supposed to be talking about on everything. And what they're going to testify to during the course of the case. Very, very fun, nice process. It's amazing how much people will forget between a deposition. You can ask a corporate president questions during a deposition, and their answer is going to be, I don't know. I don't recall. That was too long ago. I have no idea. And stupid shit. I mean, we're talking shit like they're not remembering their mother's maiden name and stuff like that. And that's because we do shit like saying, if you don't know the answer, don't answer the question. And then not don't answer the question, but don't say that you know it. I believe. If you prep somebody and they say, I believe X, Y, and Z, you say, well, do you believe or do you know? And then your client says, well, I believe it was. Are you absolutely certain? No, then you don't know. And that's your answer. I don't know. I don't recall. Are perfectly valid answers during a deposition. Clients take that to the extreme. They frequently have a habit of saying, I don't know, I don't recall, I believe, to stupid-ass questions during it. And I can see why you may want to shoot somebody as a result of that. I can understand the urge, but don't fucking do it. Are you ready for it? Are you ready? Sounds like something Michael Avanti, the porn lawyer, says. Okay. So what else do we have going on? Now, I finally got the chat. Now, for some reason, I was wondering why the chat wasn't updating. And it appears that my streaming thing with its nice little chat right there is a dick bag to me. Because it's not showing any of your chat messages where it's supposed to. So I popped out the chat, and I can see you guys are actually talking. I thought I was talking to myself for a while, which is wonderful because now it gives me time to interact with the chat as well. Patrick Roddy has said, they didn't disbar somebody. They didn't disbar the gun lawyer. And Mark Whipple, who's in the chat right now, hi Mark, has kind of jumped on that. The fact is, guys, disbarment's a very, very rare thing. It doesn't happen very often. You really gotta fuck up to be disbarred. The quickest way to disbarment, believe it or not, this guy had instead of threatening a deponent with being shot, cursing at him on the record, and answering questions for him, had this guy taken $1,000 out of his client trust account, out of his IOLTA account, oh, his ass would be disbarred. His ass would be disbarred right now. The one thing we don't fuck around with, because we are in positions of trust with our clients, is if you touch client money, you're gone. That's the quickest way to disbarment. Everything else, it's a question. It's a question. Maybe you get disbarred, maybe you don't. Maybe you just get suspended or get a public reprimand or a private reprimand or an informal warning. There's many stages to lawyer discipline. Disbarment is, by and large, the most severe because it is normally going to be a lifetime thing. Some states allow you to apply for readmission after a certain amount of time after you're disbarred, but it's very rare to apply for readmission and be granted. I personally do know attorneys who have been disbarred, have served out their disbarment period, have applied for readmission, and are essentially being told no, even though they are completely rehabilitated. And I shouldn't say attorneys because they've been disbarred. They're not attorneys. They are disbarred attorneys. They are former attorneys. They are ex-parrots, in other words. Which actually answers Ardrix's question, can you be rebarred if you are disbarred? And the answer is sometimes. If you show a lot of remorse and rehabilitation for it, you can be admitted back into the bar in theory. But as we just said, not really in practice. The weird thing about the attorney disciplinary procedures, guys, it is harder to get admitted to the bar than it is to stay admitted to the bar. Once you're in there, once you are a member of the bar, unless you're being very egregious, you're fucking with client money, you're committing felonies, you're doing things like that, disbarment's very extreme. It's very extreme. There's several stages of discipline, and we tend to give attorneys their chances to rehabilitate themselves and show that they are fit to practice law again, because obviously they were once. When you are applying for admission to the bar, there is something called a character and fitness background check. Now, every state's a little different. Some states are more in-depth than others. Some states ask for more than others do. But they will pour over everything in your background. And guys, God help you if you don't disclose something. That alone, a failure to disclose, even a minor offense that you know about on your character and fitness application, is in and of itself grounds to not be admitted to the practice of law. And you will be called in front of a panel to explain yourself. I went through that process. Several of my friends went through that process. I have at least one friend who it wasn't even due to something in their past. It was they wanted to make sure they were mentally fit, that they were emotionally and mentally fit to practice law because of a condition that arose and a circumstance that occurred while we were in law school. But they had their admission to the bar delayed by almost a year while they gained the supporting evidence showing that they were mentally fit for the practice of law. And it makes some sense. It makes some sense because this is what we do. We represent other people. We take their problems on. It's a high-stress occupation. It's very easy to fall behind. It's very easy to have problems during the practice of law. So that makes some sense. Now, that doesn't mean I'm going to start wearing my gun to depositions and threatening deponents. That, to me, seems a little overboard. Oh, and that's one cup of coffee down. On to the second. On top of our good friend, the lawyers. This is almost like the lawyer behaving badly podcast today, isn't it? Our show today. We have a lawyer who was suspended for placing a tracking and recording device in his ex-girlfriend's car. And, of course, he's from Pennsylvania. Because that's how it works. Now, guys, I actually haven't read this article or this opinion or this, oh my God, it's Mike Casale. Oh. Okay. We're going to skip through Michael J. Casale Jr., a 66-year-old attorney, was suspended from the practice of law after he admitted to police that he entered his ex-girlfriend's garage in late 2015 and placed tracking devices in her car. He had tried to retrieve the devices on 3 or 4 occasions but was thwarted because the car doors were locked. His former girlfriend discovered the devices in March of 2016. One of the conditions of his stayed suspension requires Casale to comply with the conditions of probation in a criminal case against him, which answers the question of most uniquest in there, who said that resulted in a suspension rather than criminal charges. It resulted in both, and we'll get to that here in a second. He pleaded no contest to criminal trespass and interception of communications and was sentenced to a 5-year probation and ordered to donate $10,000 to a women's program at the YWCA. His suspension is retroactive to January 4th, the day on which he was temporarily suspended. In his long practice of law, he has had no prior discipline and is remorseful for and embarrassed by his conduct. And the whole opinion's up there, right there, and I'll give you the link after this here. As a matter of fact, I'll post the link. If you want to read the opinion, I'll post the link in the chat right now as we're talking, so you can have that. Here's the thing, okay? We try to fit the discipline to the offense. You know, we have here things talking about prior cases, like Office of Discipline v. Fogarty in 2004, where he was given a 3-year suspension for breaking into a victim's apartment, installing listening devices, and then harassing a victim by email and phone for 5 months before his arrest. And stalking. He stalked. He broke and entered and eavesdropped and stalked somebody. That was Fogarty. Fogarty was given a 3-year suspension. Here is what tends to happen in these cases, okay? Attorneys are human. And as humans, we are flawed individuals who will fuck up. We will fuck up personally. We will fuck up professionally. We try not to fuck up professionally, but we do. It's how it works. So, he fucked up personally. But he is a 66-year-old attorney with no history of discipline who did something extremely fucked up. I mean, extremely fucked up. What he did was horrible. He broke into somebody's car and he put tracking devices all over them to find out where his ex-girlfriend was going. At that time, though, he was criminally charged. He pled guilty to the criminal charges. This has been advertised everywhere. His reputation is shot. And now he is serving a suspension until January. In that situation, what type of punishment could be meted out? Many. He could be suspended. He could be disbarred. A lot of people would want to see him disbarred. But he is on probation. And he has accepted the consequence of his actions legally. He has not pled not guilty, gone to trial, and been convicted. I will tell you right now, if he had gone to trial and been convicted of these charges, we would likely be looking at a much, much different situation. Okay? We would likely be looking at a situation where he would be disbarred or subject to a much longer suspension of his license to practice law, which effectively removes your ability to earn a living. You have to understand, if your license is gone, you're not working. You can't work on anything. From the moment your license is suspended, you have to notify your clients and say, my license has been suspended. I cannot practice law. You need to come get your file. You can't earn income for it. Other attorneys may not be able to employ you. There are special rules, at least in Pennsylvania, about employing suspended and disbarred attorneys and what they can and cannot do in a law office. That is more or less for a year. You don't get to earn a living. Go work at McDonald's. Who won't hire you, by the way. I mean, they won't hire you. They're not going to hire you with a JD and a law license sitting on your resume to cook some fries. And what we look for with disciplinary counsel, what we look for with character and fitness, is a fitness to practice law, a mental, emotional, physical, and ethical moral fitness for the practice of law. Accepting what you have done, not denying it, accepting it, moving forward, taking your punishment, sitting down, taking your medicine like a big boy goes a long way towards making sure that the disciplinary board and disciplinary council will go light on you rather than forcing someone to go that way. Lithorian has asked a good question. And is, doesn't the criminal justice system look much more favorably on people who take responsibility for their actions? I covered this not too long ago, actually on Twitter. And the short answer is yes. I think that question was regarding a possession of child pornography matter that was going on. The people were talking about on Twitter, and why someone would enter a plea deal if they weren't guilty, if they were maintaining their innocence. The answer is very, very simple. When you look at the sentencing guidelines in Pennsylvania for that, it was something like 9 months incarceration, or 90 days incarceration and 2 years probation was the most typical plea deal for that, whereas it was something up to 3 years incarceration if you took it to trial and got convicted. If your lawyer comes to you and says guilty or innocent, you are looking at 90 days incarceration in the local jail and a couple years probation where you'll be free but you'll be reporting to people, versus 3 years of incarceration. A lot of people are going to take the 3 months in jail in the probation conditions because they don't want to be in jail for 3 years, innocent or guilty. So that's why people take those plea deals, guilty or innocent. That's why they will take them, because we punish people who waste the court's resources and put the court through a trial. The official way to put it is we're not punishing these people. We are telling these people that we are giving them time for recognizing the severity of their offense and agreeing to accept responsibility, and whatever bullshit you want to go with on that. So that's where we are on that part. And one more moment, hold on real quick, because it has been another 10, 15 minutes or so. I wonder, do you think Rosso's been verified yet? Let's see. Nope, still not verified. Rosso is still not verified. Okay. All is right with the world. I hope somebody sends this to him. I really do. It would just be wonderful for him to be aware that I am sitting here going, is he verified yet? Is Rosso verified? Oh, no? Okay. Oh. All right. And actually, we have one more news article for today. Patrick Roddy has said, I hope that Mr. Rosso attends one of these one day. So do I. I graciously do. And if he does, if he says he's going to attend one, nobody let him know in advance that we do this. So we're going to go over to the very final one here, and then we're going to turn to the chat for a little while. Fucking A, it did that to me again. There we go. Ta-da. There we go. Okay. We're going to go over, and then we're going to turn to the chat for a little bit and talk to you guys for the last 15 minutes or so of the show. This one's actually a lot of fun. Law grad with sleep apnea isn't entitled to accommodation in bar admission process. Okay. So here's what happens. Okay. You get, if you have documented conditions, they can be psychological, they can be emotional, they can be physical. If you have documented conditions, you can apply for and receive certain testing accommodations throughout law school, such as an extra half hour to finish an exam, or taking the exam in a separate room where you are the only one there, except for maybe a proctor sitting in the corner. They do the same thing for the bar exam. You can request from the Board of Bar Examiners in almost every state an accommodation for testing so that you can sit for the bar exam in a manner allowed. Sleep apnea is one of those situations. If you don't know what sleep apnea is, it's where you either stop breathing or have trouble breathing during the course of the night. It can really affect your sleep schedule, make it very, very difficult to get to sleep, to stay to sleep, and to sleep restfully. My father has sleep apnea. I know several people with sleep apnea. It can certainly screw with things. Here is the thing that seemed to happen. Montesanti, an applicant for the Georgia bar, John Anthony Montesanti, who graduated law school at the age of 67 in 2015. Let's just be honest, that's impressive. A lot of people start second careers. Not a lot of them at 67 say, I want to be a lawyer. Applied for an accommodation during the bar exam process, stating that he had sleep apnea and that it needed to be accommodated by a disability, giving him some extra time to complete the bar exam. Now, two things. One, although he submitted his physician's letter, the sleep apnea was described as being untreated. Two is, that's all right. Here's the thing: is that there are certain things in the practice of law that you have to be able to do. One of them is to work under adverse conditions. I do know people who are very good attorneys who do have a number of conditions. My father, when I was growing up, shared his practice with an attorney who is now a judge who was blind. A funny story about that is at the time that they were attorneys, Dad's law partner worked with the county attorney's office, the district attorney's office on some matters, and as a result, he was entitled to and did receive a sighted assistant at the expense of the county. And the gentleman in question always seemed to get assistants who were very, very, very attractive women. Now, lawyers, by and large, especially litigation attorneys, we're crude. We joke around with each other, and I shouldn't say we're crude because we're not. But it is very much male, female, whatever. We joke around. We tell jokes. Most of us have a dark sense of humor on some matters. But he was walking through the courthouse with his new sighted assistant, who was just amazingly attractive. My father and some other attorneys were sitting at the canteen in the courthouse when they walked by. And as they walked by, everybody looks at his assistant, and one of the old criminal defense litigators turns around and says, I don't care what anybody says. That son of a bitch can see. But a disability does not prevent you from being a very, very good attorney. But we can only accommodate in our profession so much on that. We can only to some degree accommodate for these things. And other times you really do just have to learn how to deal with the situation. The wheels of justice cannot be particularized to every attorney, every defendant, in every situation. It's just not how it works. It would be wonderful if it did, but it's not. So having untreated sleep apnea while you're taking the bar exam, I don't get restful sleeps. Nobody's getting restful sleeps the night before the bar exam. Absolutely nobody. I myself sat up until 3 hours before the exam, unable to sleep, then took the exam and slept in my car before driving home. Nobody has restful nights prior to the bar exam, and sleep apnea is something that you do have to learn to deal with, especially in practice law, and especially if you're untreated. during it. I mean, very especially if you're untreated during it. Because that's something that will come back and you will actually hurt a client. If you're too tired in court, you can't ask the court to give you a concession in making your argument and give you an extra 20 or 30 minutes. Now, guys, I'm not the only one with this opinion. I believe we should accommodate and make accommodations for people with disabilities. Is disabilities even the differently abled people as often as possible in the practice of law? I know very, very good attorneys who are differently abled, and they may need a little bit of an accommodation to get to a certain point, but they are just wonderful advocates, wonderful people, some of the smartest fucking people in the world. And when possible, we should be making these accommodations. When possible, we really should. And I'm going to transition over this. There's no reason to leave that sitting up for the next 10 minutes as I'm talking about this. When possible, we should definitely be making those accommodations, because I can think of a huge number of lawyers out there that provide wonderful services despite their disabilities. My father's one of them. Believe it or not, I'm not coming into this and saying, oh, he has no experience. My father's one of them. My father has a psychological condition that he has been receiving treatment for the last 30 of the 45 years he's been practicing law. He is a very capable attorney. He's a very good attorney. He has been receiving treatment for his condition, and there's a lot of lawyers out there like that. And if my father contacts a judge and says, "Your Honor, can we get a continuance?" and the judge says, "Why?" Most of the judges are somewhat aware of Dad's condition, and he'll say, "I'm not having a good day," or I'm not gonna be ready, or I really just need a day to. And a lot of judges will give those continuances. But at the end of the day, whether Dad's feeling well or not, if a judge says no, he has to go into court and argue the case. And that's how it works. My father's in a unique position that Dad's been practicing 45 years. Most of the sitting judges in his area are people that know him, people that practice with him, and people that Dad has helped out over time. But there are very good attorneys out there with conditions, with different abilities. And we should, to the greatest extent possible, make sure that they can pursue the practice of law, because they're amazingly good at what they do. They are sitting judges. They are district attorneys. They are ADA lawyers. But you can't do something like, take something like the bar exam and say, I have an untreated condition, and therefore I should have been given a accommodation for it. You can't just do that. It's not how it works. If they say no, then you bring it up. But you have to have more support in it. And I know people who got accommodations on the bar exam. But they had a hell of a lot more than a letter. The Board of Bar Examiners asked for a hell of a lot more than a letter from your doctor saying you have an untreated condition. They want to see that you are not trying to game the system. And that's important. That's important because of this. When we go back to that article and you scroll down just a bit, and as a matter of fact, we're not even going to go to the article. We're going to go actually over to the Supreme Court decision on this one from the Georgia Supreme Court. He was not denied due to failing the bar for a lack of an accommodation. He was denied, and this was really sort of upheld there, because he lacked the proper character and fitness for it. There was a small judgment against him, a small claims court case. This actually goes very well into what we were talking about a moment ago, character and fitness. When he applied to sit for the Florida bar, he did not pay a judgment against him. At one point he said he forgot to pay, and at another point he said he intentionally did not pay the judgment because he disagreed with it, although he now understood he was wrong in refusing to pay it. When he withdrew, he said he first withdrew for financial reasons, then said he withdrew due to an undetermined illness. He said when he was counseling with the board, he said he didn't recall what he meant when he said undetermined illness. and that he had, and this is important here, given false, misleading, or evasive answers to bar application questionnaires. The other part of it was, they contacted his former law professors. Former law professor said that when he worked as an intern at a public benefits law clinic, we talked about those earlier, he got some negative comments about his character, which were not disclosed to him, and they failed to investigate them properly. I mean, this isn't, when you read through this, and I'll post the link in the chat, when you read through this, this is not a situation where poor man said he had sleep apnea, and the board said, oh, well, they didn't give him, he's not entitled to an accommodation. Then he failed the exam because they refused to give him the accommodation. This was the Supreme Court coming back and saying, not only did we not think you needed the accommodation, we're not really certain that we would have admitted you to the practice of law anyways, because you lack the requisite character for it. You lack the requisite moral fitness. You've given misleading, inconclusive statements. We've got negative comments from this, from your bar or your law school professionals. Insufficient candor, and Mark Whipple just hit it in the chat room. Insufficient candor to practice law, giving misleading statements. And there we go, right there. We affirm the board's decision to deny his application for a certificate of fitness, which is really the story. The story given here is law grad with sleep apnea isn't entitled to accommodation in bar admission process, court says. That's not the ruling, though. The ruling was not, he didn't get an accommodation. He doesn't get one. It was, he doesn't have the character to be an attorney. He's lying to us while we're investigating him to determine if he has the character to be an attorney. No, he doesn't. This guy said, oh, I don't agree with determinations from the board or with determinations from a court that I owe money, so I didn't pay it. I'm not going to pay it. Fuck you. Which is about as clear as like getting a parking ticket and saying, well, I don't believe I parked there, so I'm just not going to contest it. And then when they convict me, I'm not going to pay it. Guys, I had an unpaid parking ticket. You know what they did? They put a fucking warrant out for me. You know what I did? I walked down to the court and paid the fucking parking ticket. A year later, when I applied for my character and fitness application for the bar, I disclosed the fuck out of that. And when they said, why didn't you pay the parking ticket? I didn't say because I disagreed that it was owed, so I just wasn't going to pay it. I said the truth. I didn't think it was owed. I meant to do something. Quite frankly, I was in law school and I forgot about it. It was a $10 ticket. And I, at one point, honestly thought I just paid it. Like I found it. I thought I paid it. And set it aside and didn't know about it until one of the local cops knocked on my door and said, hey, you know, I got a warrant for you. You may want to go pay that ticket. And they took that. Because what they cared about wasn't that I had an unpaid parking ticket. What they cared about was me not bullshitting the character and fitness board. And 9 times out of 10, that's all they care about. Are you a scumbag who's likely to steal your client's money? Are you incapable, physically, mentally, emotionally, or psychologically, of practicing law to the extent, not just do you have a condition, but does that condition make you so incapable, and does the way you handle it make you so incapable that you are not capable of handling someone else's matter without fucking it up, without the risk of fucking it up to such an unacceptable degree that we'll do it. Guys, I want to point out how low this fucking standard is. Michael Cohen was admitted to the bar. Michael Cohen just pled fucking guilty. Paul Manafort just pled fucking guilty. These guys were lawyers. The bar's not high. It is literally not, are you a piece of shit? It's, do we have cause to believe that you're going to be a piece of shit when you're representing people? Oh. And Most Unique has asked, wait, a cop came to you, informed you there's a warrant out for your arrest and let you go take it? Yeah, I lived in a very, very small town when I was in law school, like 4 police officers small. The police station and court was half a block away from my house. They knew me. They knew I was a law student. They were giving me to the bank right then and give them the fucking money for it. And they have to take it in, let me go and lift the warrant if it's just for the payment of a fine like that. That's the way it works on bench warrants and traffic tickets on summary offenses in Pennsylvania. But yeah, it's not a high fucking standard, guys. It really isn't. And this is the part of it where we're gonna turn to you guys. It's the last, what? How much longer do we have? We started this at 11, I think. Did we start this at 11? Okay, so we got, according to this, I've been live for 20 minutes. I thought I was live longer than that. I genuinely did. I thought we started this right at 11. So I'm not sure why it's telling me I've only been live for 20 minutes or 40 minutes out of this. But we'll keep it going. So for the next 10, 15 minutes, let's take some questions from you guys, okay? And thank you all so much for coming out for the first one of these. I'm going to be doing this again next week. I think it's gone pretty well. Let me know what you'd like to see in them. But let's turn to the chat. So what about people that study in jail to become lawyers and then apply to the bar? How does that affect the bar's view? Rehabilitation. Rehabilitation is key in those situations. You have to show that you are rehabilitated, that you are ready to enter society, and that you are now capable, moving forward, practicing law diligently and bringing honor unto the profession. There's actually a case in Louisiana where a gentleman who was convicted of murder, served his time, got out, went to, I think, LSU's law school, and character and fitness determined that he was capable of practicing law because he was able to show rehabilitation. There is a case in Washington, I believe. A young lady was, and she's not young, she's probably about my age, maybe a little older, actually. But a young lady practiced law or studied law after a lifetime of, an adult lifetime of really being a career criminal, but drug use mainly. You know, nothing violent, no financial crimes. Went on to become a sterling law student, won a prestigious public service scholarship and an internship and clerkship after that. The state was denying her admission to the bar. They wanted to do a very heavy character and fitness background check. Several letters were written by a lot of members of the legal community and supporting her. I believe that she is actually admitted now. The one thing that you're probably going to have way hard times overcoming is what Mark Whipple just hit. Crimes of moral turpitude. Moral turpitude are crimes like fraud, embezzlement. They are crimes like perjury, showing a lack of candor or an inability to be honest to a tribunal. Those are crimes of moral turpitude. And we're not talking about this in the immigration sense, because I'm going to be completely honest. Crimes of moral turpitude or in violent crimes, things like that, are generally crimes that get people deported in immigration, but immigration law is weird, and they will redefine a crime to be a crime of moral turpitude whenever they damn well feel like it to throw your ass out of the country if they can. When it comes to the bar, we're talking about the classics. Murder always, rape always, burglary sometimes, perjury definitely, embezzlement definitely, fraud definitely, anything that shows a lack of candor, a lack of honesty. Those are the things that we are looking at. They are, if you look in your state's laws, go to your state's laws, there's probably a section in the criminal code that's something like crimes against public decency. Almost everything in that is going to be a crime against a crime of moral turpitude. And they look at those very, very heavily. They look at them heavily, and then they turn around and say, have you rehabilitated? Are you still a concern? Most Uniquest just said, talk about pro bono. We talked about pro bono for a good chunk of the beginning of this. To quickly rehash, though, everyone needs a lawyer. And we should be heavily funding pro bono grants and organizations at the highest levels of government, because a civil judgment where you are not entitled to an attorney, you're not entitled to an attorney in most civil matters, can fuck up someone's life just as much as a term of imprisonment. It can restrict someone's liberty and fundamental rights just as much as a term of imprisonment would. The fact that the LRC, the Legal Resource Commission, our company is a corporation, is being is that Trump is talking about defunding that, makes me sick. Pro bono is a wonderful thing. I take 2 pro bono cases a year. I take much more low bono cases. But yeah. And guys, I'll take one more question, and then we're going to go ahead and call it, because I'm almost out of coffee. I'm definitely out of cigarettes. And I have another stream, a game stream, to set up for this afternoon. So we'll take one more question out of the chat. Whoever wants to toss it in there, go ahead and toss it in there. We'll talk about it for about 5 minutes, and then we're done. We are done. We're out of here. We're outie. We're gone. Yeah. Mark Whittle said, oh yeah, Mark Whittle said he knows somebody who makes more money in a brothel than they do being a lawyer. It's technically the same thing. We're whoring ourselves out either way. And Falconio with the last one. What is the difference between a person going to jail or prison, or are they the same thing? In my jurisdiction, there is a difference. In my jurisdiction, there is a very definite difference. Jails are on the county level. They are county detention centers. Prisons are state-run facilities. A jail, so you go to the county jail, you go to the state prison. Okay? Now, in my state, if you are sentenced to a term of 5 years or more, you are automatically going to prison. County jails cannot hold you for more than 5 years. If you are sentenced to a term of 5 years or less, you may be in a county jail. Somebody said jail is more like county lockup, which that's very dependent on where you are, because it is and it isn't. Our jail here is a jail. It's a jail. People are there for up to 5 years. And it can actually be a huge benefit to have that distinction. You will see sentencing ranges that stop at like 59 months. Because that is the cutoff for that crime between jail and prison. Some people want to serve their time, even though prisons are typically larger and have better resources. Some people want to serve their time in the county jail. Why? Because they're from that county. That's where their family is. Their family can come and visit them there while they're doing their 3 years or their 59 months. Whereas if they hit 60 months, they're going to the state prison, and the state's sending them to whatever fucking prison has availability. Doesn't matter if it's on the other side of the state or not. And it makes it much harder to visit, much harder to do things. And that's why we have these really weird sentencing guidelines here that'll stop just before that. So that was the last question. The last one. And I'll actually, hold on. Somebody in the room saying it's 1 year here. I think it's 5 years here. I think it is. I wouldn't know. I don't do a lot of felony work. I mean, just to be frank, I don't do a lot of felony work. I did when I first started practicing. I don't anymore. So we're just going to look up jail sentence or prison sentence and just see where it is. Do-do-do-do-do-do. Do-do-do. Yeah. Okay. So yeah, we call them state sentences versus county sentences. Yep. Okay. All right, I'm pretty. I think I'm right. 2 years. 2 years or more. Okay. It's not 5, it's 2 years. 2 years or more. But that's why you see like 13-month or 23-month sentences. Like 2 years or more. I don't do a lot of felony work, guys. I really don't. I just, after years of not doing it, I've just now gotten back into criminal defense, and I'm only doing misdemeanor cases at the moment. So, So I did misspoke. I did misspoke. I did misspeak. It's not 5 years. That's the bench line. It's 2 years. Here. So, guys, that's it for the first show. Thank you very much. I hope you enjoyed it. Please give me feedback over on Boozy Barrister at Twitter or boozy@lawyersandliquor.com, or if you know the Badger, send it to the fucking Badger. I'll live. So that we can discuss that stuff. I'm going to be back on the other Twitch channel later on today with some streams. So we're going to be going on there and just kind of streaming. But hopefully if you enjoyed it, we'll be back next week. Thank you so much for tuning in for the first one. And guys, it's been wonderful talking to you this morning. I really enjoyed this, and I really enjoyed the format. Like I said, any improvements, please send them to me at boozy@lawyersandliquor.com, and we'll talk next time. Thank you very much, and you guys have a great Sunday.